discharged by performance. From section 56 clause 1, when a party promised to certain things at or before a specified time, the contract or so much of it has not been performed. Relevant case between Sim Chiu Huat v. Wong Tet Hui, the innocent party has the right at the rescission or trade as it stays subsisting. The next is place for performance. From section 50, when a commitment is to be fulfilled without the promises application and no location has been set, it is the promiser's responsibility to contact the promisee and requires that a suitable location be set for the fulfillment of the promise. For relevant cases between Iman want to deliver the goods to the Akram, Iman should appoint Akram for a reasonable place and deliver it at that place. So Iman cannot to deliver the goods to the other place. The last is performance for third party. From section 42, if the promisee accepts performance from a third party, he cannot enforce it anymore against the promisee. From relevant case between Chin Sui On v. Puchong Realty's neighborhood, respondents have implicitly acknowledged the third party's performance of the applicant duty to pay his debt according to the Supreme Court. We move to discharge by agreement. If all parties agree to terminate the contract and free each other from their contractual obligation, the contract may be discharged by consent. So if any parties want to terminate their contract or free each other from the contract, they can terminate. They can discharge by consent or agreement. Section 63. The original contract need not be fulfilled if all parties want to substitute or rescind the contract. So that means parties can substitute or change the contract if they want without fulfill or perform it the original contract. From section 64, every promisee has the right to dispense with or remit the performance of the promise made to him in whole or in part, or to extend the time for such performance, or to accept any satisfaction in lieu of it. Right. The next is this. There are forms discharged by agreement. The first one is novation. New contract is made to substitute the original contract. All parties must agree. Right. For example, Ali owes Ahmad under a contract. It is agreed between Ali, Ahmad, and Shafiq, for example, and Ahmad should to accept Shafiq as his debtor. So the old debt between Ali and Ahmad is terminated. The new debt from Shafiq and Ahmad is under a contract. Right. The second is alteration. The obligation to perform has been discharged by agreement. For example, is Ali and Ahmad under the agreement want to purchase their car with in 100,000. The both of Ali and Ahmad agree to change the price of purchases of car from 100 to 95,000 ringgit, and the obligation to buy 95,000 is discharged by agreement. Next is rescission. The contract is discharged by agreement if both parties agree to put end to the contract before they finish it. For example, the contract discharged by agreement if Ali and Ahmad want to end or terminate the contract. Right. The last is remission. Ali owes Ahmad 10,000 ringgit and Ali just paid 8,000 at the time and place. For 10,000 is discharged by Ahmad.
So now I will discuss about discharge by impossibility or frustration. So it is a contract that is discharged if there is impossibility of performance of the contract. So impossibility occurs when a party is not able to complete a contract because of an event that happened after the contract is executed. Impossibility also means the contract cannot physically be performed. Meanwhile, for frustration or impracticability, it occurs when a performance will be deemed impractical because of an unforeseen event. So frustration also means a contract cannot be performed because of an extra burden to the contracting parties. So the first one is impossible to be performed. According to section 57, it is an agreement to do an act impossible if in itself is void. It is an arrangement to perform an act that is impossible from the start, whether or not the parties were aware of the impossibility that is void. So the next one is impossible to be performed after a contract has been made. So according to section 57 clause 2, a contract to perform an act that becomes impossible or unlawful after the contract is created due to an event that the promisor could not avoid becomes void when the act becomes impossible or unlawful. So the first one is the destruction of the subject matter of the contract. Subject matter of the contract was destroyed without the fault of the contracting parties, but it could be due to an act of God, like flood, earthquake, or fire. So, for example, case Taylor against Caldwell, the contract was held frustrated by the court. The second one is supervening events which defeats the whole purpose of or subject for the contract. So, in this case, contract is entered into a specific purpose known to the other part and something happened beyond the contract which results in the contract to be defeated. For example, case Creel against Henry, the court was held frustrated as the coronation was postponed when Rome was hired specifically to view the king's coronation procession, but the contract was held frustrated because the king's coronation got cancelled. Now let's move on to death or personal incapacity. So in this case, party to a contract may be excused from participating if the performance is contingent on that person's life, or if the party becomes unable to fulfill their obligation due to illness. As a consequence, if a contract involves a personal success by the promisor, the contract will be terminated by his death or incapacity. So for example, case Robinson against Davison, so the court had said that the contract was frustrated as she became ill without there being any mistake or negligence on her part. There was a contract between the plaintiff and the defendant's wife who agreed to perform piano at a concert. So the next one is change in the law in beyond the control of the contracting parties. So in this case, the law is amended and the amendment affects the liabilities of the contracting parties, causing it to be impossible to be performed. For Cheng Sang-hao and Ors against Wang Girls in Denver High 107, the SPA had become financially difficult to conduct the due diligence in circumstance according to the court. The next one is discharge by breach of contract. So in this section 40, when a party to a contract refuses to fulfill or is unable to perform his commitment in its entirety, the promise may terminate the contract unless he has demonstrated his commitment in its continuation by words or actions. Case 1 encounter concerns against McGregor. So the court held that the claimant was not obligated to accept the breach of contract and could not continue with the contracts, so they were thus entitled to full payment for the 3 years advertising.
We explain about remedies for breach of contract. Rescission of contract. Under Section 40, if a party in contract breach the promise, the party not in the breach can terminate the contract. But under Section 65, if the party not in default choose to terminate the contract, the other party must restore or return the benefit he received. Based on the case Muralida Chatterjee vs International Film Court (ICD), the result for this case is the party not in default must restore the benefit he received from the party in default. Next is damage. Under Section 76, if a contract rightly rescinds, a person is entitled to compensation. Instead, in case Susan vs Chan Solfa, the result from the court is the plaintiff rescind the contract and refund the sum of deposit plus interest to defendant. There are types of damage. First is damage arising naturally or ordinary damage. Under Section 74 Clause 1, two parties made a contract but one of them broken by naturally arising ought to receive compensation for the damage. It can be seen in case B. Chonra vs Japarahai vs Lu Samoy, where the respondent was entitled to damage because of the delay in completion, ordinary house, and cost of living. Special damage for any special loss extends. Section 74 Clause 2, compensation for special damage is not to be given because the party can foresee the losses in making the contract. This can be seen in Victoria Laundry vs Newman Industry Ltd case, where the result is laundry profits were recoverable, but the loss of dying contract was not recoverable. And last is liquidated damage. Under Section 75, the parties that have made a contract have stated the amount of damage need to be paid if there is a breach of contract.
Here I will explain about specific performance. What is specific performance? Specific performance is a court order that requires a party who is in breach of the contract to perform a specific action according to terms of contract that have been agreed. This remedy based on description of the court that stated under Section 21 Relief Act 1950, as it is basically equitable remedy. In specific performance, there are two situations. First situation is situation where specific performance may be granted. There have 5 sections in this part. First section is section 11 clause 1 clause A is when the party agree to be done the act to the performs whether in wholly or partly based on trust. Second section is section 11 clause 1 clause B is when there no exist standard for ascertaining the actual damage caused by the non-performance of the act agreed to be done. Third section is section 11 clause 1 clause C is when the act agreed to be performed is such that its non-performance will not afford adequately relief. Example case in this section is Daniarity Sedang Berhad and Ors versus Nicholas and Ors. So the result of this case after being held is the court dismiss the application. This because the share is not available in the open market. Fourth, section 11 clause 1 clause B. It is probable when no pecuniary compensation be got for the non-performance of the act that have been agreed to be done. Last section in this part is section 11 clause 2. Even if it still not be proved, the court still presume that the breach of the contract to transfer any immovable property which cannot adequately relevate with compensation in money. Example case in this section is Saibunsa binti Shaikh Ahmad versus Lokun Moy and Anor. The result of this case after being held is the court give granted specific performance on this case. Now I will explain a situation where specific performance cannot be granted. They have three sections in this part. First, section 20. Section 20 is when the contract made based using money compensation for the non-performance party is inadequate remedy. Example case in this section is Yo Leong Seng versus Lucky Park. The result of this case after being held is the court refused granted specific performance as damage could provide an adequate remedy. Now I will explain section 21 clause 2. It gives the court the discretion not to enforce specifically a contract. First, it gives an unfair advantage to the plaintiff over the defendant when they not have fraud or misrepresentation on the plaintiff part. Lastly, section 18 clause 3. The court have a power to award compensation as addition to specific performance if specific performance is not sufficient to satisfy the justice of the case.
What is injunction? Injunction is a court's order to restrain the doing, continuance, or repetition against the contract. Under Section 50 of Specific Relief Act 1950, if the contract contains a negative agreement, the court can prevent it by injunction. And next is types of injunction. There are two types of injunction. First is temporary injunction. Under Section 51 Clause 1, the court can order when to continue and regulated by the law relating to civil procedure. This can be seen in case American Ceramic Co. vs. ASYIKIN, where the result is if the plaintiff's factors were evenly balanced, the court would grant to maintain the status quo. Next is perpetual injunction. Under Section 51 Clause 2, this can only be made during the hearing to avoid defendant from doing an act or assertion against the plaintiff. Next is situations where injunction cannot be granted. Under Section 54 Clause F, if contract of performance is not specifically enforced, the court cannot give any injunction to prevent the breach. But there is exception in Section 55, where the court cannot give any injunction to the contract because the affirmative agreement coupled with a negative agreement should not preclude. This can be claimed in case Lumley versus Wagner, where the result is the court did not order Wagner to sing at Lumley's theatre, but the court granted an injunction restraining Wagner from singing for C at the Covent Gardens.
Now I will explain about Quantum Merit. As much as he deserves, which is a claim for reasonable remuneration for the work that have been done that supply under the contract. When the breach of the contract happened, they have two kind of case that claim arise. First, when the party evidence or refuse to perform the contract. Example case is Blanche versus Colburn. And lastly is when work has been performed and accepted under a void contract. Example case in this part is Carbon Alice versus Canon.